Good evening, everyone. My name is Harshita Singh. I'm a legal intern in LEXIS and Company. So today's topic of my presentation is vicarious liability. So talking about the vicarious liability which is present in torts, we should know what is tort. Tort has derived from a Latin word tortum, which means to twist. It is a breach of a duty. Here, duty denotes a legal duty and not a moral duty. And this duty must have caused some injury. So, the person who commits tort is called tortfeasor or a wrongdoer. And if the tort is committed by a multiple individual, it is called joint tortfeasor. Tortfeasor. Wrong conduct which, though beyond the contract and trust, give rise to claim for compensation. So, vicarious liability is liability of a person for an act committed by another person, and such liability arises due to the nature of relationship between these persons. It is basically master-servant relationship. So master-servant relationship is where a master is held liable for the conduct or for the act of his servant. The act must be authorized by the master. Even if the act is not authorized by the master, but it has been done in the course of the employment, then the master will be held liable. For example, if the master has sent his driver to bring vegetables from the market, and the driver, due to rash driving, has dashed in someone, then here the master will be held liable and not the servant. So this is due to the relationship between them. The tort is there must be two essential. Tort must be committed by the servant, and the tort committed by the servant should be at the time of employment. The liability of the master is based on two maxims. Maxim is quil facet per alium facet per se, that whenever person gets something done by another person, then the person is viewed to be doing such an act himself. The other maxim is responded superior. Here it means that the subordinate should not be held responsible and the superior should be held responsible. The act done in a wrong or rightly manner will be considered to be done by the master himself, and in both cases he will be held liable. If an invention is done in a company by an employee, the employer will be liable for that and not the employee. So in a partnership and firm, here partners are responsible for each other's action during the course of the employment. They are held liable jointly and severally for each other's action. For any partner's action, one can sue each other. And principal-agent relationship. An agent is a person who acts on behalf of the principal. Therefore, if an agent does a wrongful act in the course of employment, then the master will be held liable for the same. But if the principal is not aware about the act done by the agent, which is in benefit of the principal, then here also the principal will be held liable for the same. We'll talk about master-servant. We'll talk about independent contractor and servant in the next video. Thank you.